First of all, I would like to thank you for this opportunity, which I think is very important. I think that it's very important that we have this webinar organized in Sicily, where we have the project leader. And actually in Italy, in Sicily in particular, there are some major events taking place. There are also some contradictions when we talk about justice and justice for unaccompanied foreign children. So going back to what was discussed and debated yesterday, I think there are some aspects that make it clear that it is quite difficult to talk about the child-friendly justice within a context where there are lots of shortcomings, dysfunctions, also I would say structural discrimination against sorry, my telephone keeps ringing. I have to silence it. So I was saying a structural discrimination against young people coming from other countries outside the European Union. So it's difficult to talk about justice without considering the context where foreign children are accepted and welcome, and how much this is in line with the principles and with the rules that should somehow govern the relationship between the system, the judicial system, and children. I think there is some convergence between what we can analyze about the number of foreign children in Italy and Europe as a whole, and all the issues concerning justice itself. I think we need to talk about this sort of convergence, and actually from the second session yesterday, this was made quite clear. That is to say, justice measures are somehow a sort of last resort. The answers are provided to issues, to problems that should be examined even outside the court system. So we have to have this convergence, and we have two areas where we work, one concerning foreign children, and then we have the justice system on the other side. So in this way, we have to point to the necessary integration. And this has to be done by joining together these two areas. So without looking at the context, without looking at the root causes, I think we cannot actually talk about proceedings, juvenile criminal proceedings, and children that are subject to this youth justice system. Unfortunately, there is this gap between these two areas, and there is a big gap between regulations and facts, actual situation. I won't delve on the existing legislation now. The only thing I want to do is that what is written on paper is only partially applied. And if it is applied, it is done so in a fragmentary way, and obviously this doesn't help in preventing, for example, crimes, etc. If we do not deal with this sort of connection, I would say it is impossible to have a more virtual analysis where we look at the principles, we examine the principles, also the same principles should be translated into practice, which is not always the case. So yesterday we were talking about individual assessment as one of the focal points in our conference. And interestingly, I think we would have to have a sort of general assessment, not individual assessment, a general assessment, a collective assessment, because without it, we won't be able to apply those principles that are necessary for an individual assessment for the individual child, and that help us identify the individual features of each child, of each history behind a child. So we need a sort of more system-based approach, integrated approach to actually answer to this very difficult question raised by this webinar, that is, can justice be child-friendly? So this big question mark, I think, is also the core of what all our analysis should be. Yesterday, we discussed about children who are victims or offenders. In both cases, we talk about children in a condition of vulnerability. Actually, one of the early or the first speakers spoke about human trafficking, and obviously this issue of human trafficking has to be dealt with in terms from a criminal point of view, but there is some sort of reluctancy around this topic. That is to say, human exploitation and trafficking, actually on an international level, they are linked to circumstances and contexts that produce vulnerability. For example, I would say that today it is still very difficult to consider human trafficking and exploitation as integrated processes and consequences of the system which is producing vulnerability. And I would say that there are also criminal responsibilities as to the violation of human rights of individuals, but there are also responsibilities, shortcomings leading to this type of exploitation.
Di reato, le vittime di reato, come il prodotto che genera.
We might think of this as a context that generates vulnerability, the context that promotes the concept of justice. So you can imagine the type of contradiction that we have, a situation in which the whole justice system, the institutions proposing the concept of justice, are the same institutions that, due to omissions, due to mismanagement, or due to particular interests, I'm referring to organizations that should be participating in the response to the problem, but they operate in a closed manner and they belong to the problem. So this context generates vulnerability and a phenomena of exploitation, abuse, violation. So I propose this analysis. I widen the horizon, but I propose to start thinking of this context, of the analysis of this context as the way to find an answer to this issue, to this question coming from our meeting. And Having said this, in addition to the details that will be stressed in next presentations, I would like to refer to three particular dimensions. They are general, but they are particular. First of all, the Convention on the Child Rights of the United Nations, ratified in 91 in Italy. It is our law. So we talk about the best interest of the child. So we must consider how and how much this convention can be an instrument of orientation for practices, policies, and strategies. In our DNA, we have this convention within our organization, but this convention is not known, is not applied, and it is not considered as a primary reference in the analysis and in the action. So the first proposal in terms of convergence between the theory and practice is to say, if we want to talk about justice, we have to manage to qualify this convention that must be a primary instrument of analysis, not only for jurists, a general reference for all of us, because we all agree with the rights of a child and adolescents. It must be a working instrument in order to analyze a context and to analyze what the context means for a person. So there must be a comprehension. There must be the implementation, not only in juridical terms. I remember that the convention is multidisciplinary, created by jurists and by experts in psychosocial subjects, pedagogists. So this convention is rich in meanings that are not used yet. So how much is this convention used? For example, a reception center or the justice system. How much can this instrument be used in terms of principles and regulations proposed by this convention? And so I invite you to consider this convention as an underused instrument. This convention dates back to 1989. We are in 2021, and only a few people know and use this convention as a reference instrument in determining analysis and practices. The second reference that was mentioned yesterday is 448, dating to 1988, a year before the International Convention on the Child's Rights. So our system developed a philosophy and an approach to child justice that was innovative. It is still innovative. It had a specific vocation in dealing with the subject, but it was not specialistic, because it considered what before and after justice system was for that child. So it proposed a pedagogical vision in line with this idea proposed by the international legislation in its articulated expression of the subject matter. Some conventions were mentioned yesterday. 448, therefore, as a capital that is present in our country, that reflects the principles and standards of the convention, but unfortunately, it is underused from the point of view of the relation. Yesterday, the ladies of USM said that this lack of connection between the justice system and what is around before and after. So if the general reference can be the convention on one side, but on the other side, we have a legislative capital translated into the 448. We talked about individual assessment in an emancipated manner as compared to other systems of other countries. Our legislation and our regulations concerning children was summarized in the specific aspects of foreign unaccompanied children, and there was the law 47 of 2017, and the article 1 says that any foreign child has the right to the same opportunities as Italian children. So there are no differences in our system between the guarantees for a foreign unaccompanied child and a national child. So there is a series of principles put together in this law, translated into accurate, precise indications, practical indications, starting from the connection of our legislation with the international principle. The Article 1 connects this specific law on foreign accompanied children to the corpus of orientations coming from the international legislation. The comprehension and the application and the integration of these three instruments can give an important orientation in terms of response to this issue. The justice can be child-friendly. The divergence between theory and practice can give a response. I would like to share with you a map that we are making. So we observe a law 47 in different Italian territories, and we tried to translate into more comprehensible and direct indicators the various points of the law. I think that it is interesting to share with you this type of map because we realize that Law 47 proposes a series of elements that are relevant and important in order to prevent any violations and not to make a foreign child a victim, and to make him or her, to place him or her in a position not in conflict with the system. So this law, if it is meant this manner in the relation between the various specific aspects, can be very useful, I think, to allow us to understand something concerning the issue of today's webinar. I will not detail the particulars, but I invite you to consider the implications of each element in determining a more balanced and credible condition as to the concept of justice for foreign unaccompanied children. We talk about qualified reception, and we know that it is not qualified in our country in quantitative and qualitative terms for foreign unaccompanied children. There are some virtuous situations, but there is a disproportion between the presence of children and the conditions that make this reception qualified. Considering the distribution of foreign children on the national territory, we see that there is a disproportion between the numbers of children received in Sicily and the others received in the rest of the country. I'm referring to competencies within the facilities, connections between the facilities and the institutions and the reception centers. And I'm referring to the possibility for a child to find a context that can cope with his or her conditions. I always remember Article 1 of the law. There must not be a parallel system as compared to the system of Italian children. The quality of receipt is a problem. In many cases, it is not qualified reception. And you can understand what this can cause in terms of vulnerability and the conflict of children with a system that says that it receives, but it receives badly, actually, in a situation of emergency. And the foreign children in Italy are an historical phenomenon. So the issue of guardians, Law 47 envisages a voluntary guardian for every foreign child. This profile is very much at risk at this moment in time, because very often there is no guardian. In most cases, there is no guardian. And some institutions act as guardians that cannot give the right, cannot have the right care that each child should deserve. There is a problem of training. There is a problem of presence, of clearness in terms of these institutions, and the national organizations have problems in qualifying this profile that is very important. So you can understand the difference for a child to have a person who devotes a part of his or her time to support his or her difficult life path. So this is a chronic deficiency of the system. And so the institutions are very weak in terms of training. Yesterday, the lawyer who talked said that it is necessary to specialize these profiles, but guardians are no micro professionals, but they need to be trained and supported. So the institutions must be responsible. I'm referring to data sharing, for example, so the social files, the documentation concerning a child is very weak. The different institutions do not coordinate in terms of data. So this phenomenon is blurred. And there are situations, therefore, of vulnerability and of conflict for a child in a system where where the child is not recognized in terms of right. I'm sorry. I'm I'm sorry, but I'm asking you to come to the end, to the conclusions. So, listening procedures, the identification interview, the assessment of the age, the relations between our institutions and the family of origin, and then the majority. And that is really a big, great problem for children. How can we think of a system of justice that do not, a system that does not consider the coherence of our analysis of our action in terms of what the law envisages? So, will it be possible to talk about a type of justice that is a friend of children in a context in which this justice is system, policy, and jurisdiction? When we recognize that this system is not suitable, so we will deal with the individual evaluation. And I think that this is a path, a precise path to generate the credibility and the sustainability of a justice proposal for foreign children. And to conclude, I come back to the convention talking about the best interest of the child and about three other main principles: the maximum guarantee in terms of possibilities of development of that child. Two, the issue of non-discrimination. We know that, as already said, foreign children are still discriminated on our territory. In terms of what the law envisages, because the law says a treatment of equal opportunities. And so, due to a vulnerability that quite often is determined by the system. And the third principle, the participation. So there is this issue of the invisibility. Invisibility that is shown in very forms, present in various forms, in which the context of being an offender or a victim. So all this is shown in a strong manner. So when we talk about the best interest of the child, we must have clearer references in terms of national standards, not only in juridical, in legal terms. We have to apply a paradigm that can be credible for these children. So there is a problem of continuity of our analysis made of knowledge, of practices. I have concentrated on critical elements. I know the efforts of the operators working in this system, of the professionals working in this system, but I'm trying to show you a basket of elements, and this is a complex logics, but it is necessary to deal with the issue of this webinar. Thank you very much, and sorry if I have been so long.